Okay, well, there's a red light on. Good? Okay. So today we have as our guest speaker Jim Arnold, who is an environmental attorney, and he is the principal of the Arnold Law Practice in San Francisco and the East Bay. Jim is a member of the executive committee of the environmental law section of the Bar Association of San Francisco. The Arnold Law Practice celebrated its 15th year anniversary on July 4th of 2013. Jim is also a founding director of Core Environmental Inc., which is a 501c4 nonprofit which focuses on legislation for effective and cost-efficient remediation for contaminated land and groundwater. Jim joined Core because he believes that with a little bit of help, our government could work a lot better than it does. And today, Jim is going to be speaking to us and giving us an environmental law update for 2014. So please welcome Jim Arnold. Thank
you. Well, this is sort of apropos of dealing with toxics. You walk very carefully, watch out for the hidden prizes, and you every now and then you step in it. I had a friend who said about Texas, you know. I said, how do you find Texas? They said, well, you go east until you smell it, and you go south until you step in it. That was sort of a California thing about Texas.
Easy on that.
Well, it's when you get all the talk about the fruits and nuts in the bowl, and tip to the side, and they all roll out. Yeah. Let's see here. We're going to put ourselves back. Well, maybe we aren't. Maybe we will. Maybe we won't. Come on, machine. Do your thing. Oh, it doesn't like me now. Oh, there we go. Hum away a little bit, please. Wait a minute. Okay. Anyway, you get a chance to see that sort of cattywampus picture there. It's a very typical type of site where everything's a big mess, an old gas station, and it eventually becomes a ice cream store. Or not. Depending on... No, Marcus, I think we're going to have some help here. Oh, wait a minute. There it is. Pick up that. Really will good. Oh. Are we in luck? We are in luck. Well, good. Sort of like when you're waiting for your groundwater test results to come back. You know, you're sort of on the edge. Huh? Yes. You don't know if you really want to know or not. Well, okay. I set off in a somewhat ambitious way to provide an environmental law update for real estate attorneys. And I can't say that I've covered everything, but I think I've covered particularly some of the things that you may not have already heard about ad nauseum. No guarantee that we won't be ad nauseum when you get done with this, but okay, we'll just do the best we can here. There we go. The three topics are going to be new laws, regulatory agency developments, and then liabilities in the courts, and then how about solving some real estate problems with all appropriate inquiry? And how far are you going to go with that? There are three concepts that I think we all have to keep in mind. Because the environmental liabilities are status-based, okay? It isn't that you put your hand in the cookie jar. It isn't that you had bad karma in another life. It just is. It's about the same as customs laws or whatever. It's based on your status. If you're an owner, an operator, a person in charge, a discharger, a responsible corporate officer, you have liability. You can even be the manager of an LLC and have liability. The second thing that we have to keep in mind is predictability. To a greater or lesser degree, I've come to the conclusion, elementary as it might be, that people hire lawyers for a lot of reasons, but one of the main reasons they hire us for predictability. That we know enough about the law to tell them what's likely to happen if they go one direction or another, or if we write something up in a certain way or handle it in a certain way. The third thing to keep in mind is prioritization of risk. Must always, what is the more important thing? For instance, when a CPA comes to me and says, gee, Jim, I've got a client, he cleaned up this site 5 years ago and he's had this corporate entity, and I just got hired by him, and I think we could save $150 a year if we could wrap that thing up and dissolve it. And I said, well, I wouldn't advise it. I said more like, are you crazy? That's about the only thing that's standing between him and liability, because a lot of toxic situations and properties are sort of like vampires. Maybe they come out when the moon is full or something, it isn't all done. It never is all done, particularly with the way that we look at chemicals and toxics and whatnot. As we're sitting here today, the vinyl chairs that we're sitting on and the cushions in the vinyl chairs are probably full of a flame retardant chemical, which has been tied to health problems for firemen in San Francisco because they burn. It does burn at some temperature, and they, of course, breathe it as they go counter to everybody else. Everybody has to ring out of the building, and they're running in. Of course, that has something to say about them, I suppose. Thank heavens. Anyway, laws and regulations. In your papers I passed out, there's more of a discussion about what's going on with these various laws, but I tried to go through and find the laws that I felt that would have some bearing on real estate lawyers. Sea level rise seems like something that's sort of out there, but if you're going to be a dirt lawyer, you kind of hope that more dirt stays around and isn't covered by seawater. So the sea level rise issue is that the ports in the Bay Area have been designated trustees for natural resources. And they're come up with a plan about what sea level rise will do to the quality of the natural resources that exist in the seabed or in the near shore. Air quality issues are also a big and important thing. There's not as much as you might think going on with a lot of these statutes. One of the reasons for the somewhat lessening of major environmental law programs is term limits. Byron Scher was a professor of law at Stanford, I believe, and also a longtime assembly member. And before we had term limits, a person like that would be in office for many years, and you would see sort of comprehensive programs come through. Instead, today, in the modern time, we have programs like AB 32, which is global warming, greenhouse gas. That was put through by Schwarzenegger. There's sort of a contrast there I enjoy between Byron Scher, law professor, and Schwarzenegger, part-time governor. So that's what we're getting, So here we go. Air quality. The one issue here is that the funding formula that brings about $500 million from the federal government for mitigating traffic congestion, which is very important to all the counties and local entities, metropolitan planning organizations. That's being continued. It's being stepped up. We have, I just barely mentioned the anti-fracking bill. Fracking is also called well stimulation treatment activities. So it's always said how you call it, But anyway, you may have clients who have concerns about water wells or have concerns about possibly earthquakes. They've happened some places, but fracking is a very simply is a system where they pump water with a lot of nasty chemicals in it under very high pressure down into oil deposits to break up the deposit enough to be able to pump the oil out. And it generates a tremendous volume of wastewater, which is disposed of by drilling a well that's, say, half a mile deep and pumping it down that well. Maybe let somebody eons from now take care of it. But the governor had he gave in to the oil companies. There was quite a push to have a ban on fracking in California, but he came back and supported this bill, which is a information-based bill. So if somebody is actually going to engage in fracking in an oil well, and there are oil wells everywhere. They actually drilled for oil in Orinda, I think, back in the day. So the operator has to notify the surrounding water well owners, and they actually can require the oil well company operator to hire consultants and do studies and report on what the contamination might be in their water wells. And as a trend, those results are then posted on the internet. So you'll see throughout the environmental world, environmental issues and whatnot, more and more and more information is being posted on the internet. So a piece of advice, if you're setting up an LLC for somebody, don't encourage them to put their own name on it, because it will be there forever, just like your unfortunate afternoon that was picked up on Facebook. So you kind of want to not do that. If you're going to have an organization or something, it'll be tracked forever, particularly if it's a contamination situation, because the systems that we have for tracking contamination and cleanups and whatnot are getting more and more extensive. And the two agencies we have are actually integrating and cross-referencing their databases on the internet. Land use laws was AB 116. It's an extension for the tentative maps, investing tentative maps that were delayed by the big recession. Then there's a little bit of law there, or SB 341 by Desaulniers, to streamline some of the transition from the redevelopment agencies over to the local successor agencies. But we'll get into something interesting in that realm in a minute, namely AB 440 by Gatto. AB 227, I don't have that there, but anyway, it's a hazardous material issue, and it puts some controls on citizen-sued plaintiffs. If you remember I think the last meeting we had a very excellent speaker on ADA and how aggressive ADA plaintiffs make life miserable for small business people. Well, the same thing happens with Prop 65, where they come into a bar, a restaurant, coffee shop and say, you don't have any visible warnings, you've got cigarette smoke, or you've got combustion products, or whatever, and we're going to sue you if you don't pay us. This bill came through, 227, which helps owners of bars, restaurants, and coffee shops, if they correct very quickly, if it's an honest violation, and they put a notice, they serve the notice on plaintiff's counsel, all they have to do is pay $500 as a penalty, and life can go on for them. AB 127 is what I mentioned before, is that flame retardant chemical, which is starting to turn up now in, crib bumpers? Yes. Probably explains why my kids don't like me. They got exposed or something, but they were small. But anyway, it's a flame retardant chemical that was used pervasively in lots of things, because it does prevent fire and flames and things like that, which you want to keep out of homes, and particularly people used to smoke cigarettes, couch fires and things were a big deal. Anyway, that's being phased out because of the problems with it, and they're going to. It's also been used as insulation in buildings. I expect to see something like asbestos remediation take place within the next 10 years, where buildings will, particularly buildings, will start to remove that material and put in whatever the next new thing is. I mean, those of us that are familiar with asbestos remediation in buildings, seen what that's been like. AB 1329, do I have that up there? Yeah, there it is. It's a focus on low-income communities. It's basically an environmental justice law. Throughout California, we have 118 permitted hazardous waste disposal facilities. For instance, if you drive south on I-5 just after the Tracy cutoff, you look over to the right, there's this big thing, looks like maybe a prison or something. Well, that's a massive hazardous waste disposal facility where they bury stuff and incinerate stuff, this and that. There's not much of a community around it except maybe for ground squirrels, but you sort of get the idea. Hazardous waste disposal facilities are a necessary element in our society and what we live with, but the problem is that you can't really have people living close around them. So they're going to prioritize enforcement by the Department of Toxic Substance Control against these facilities, the facilities particularly that are in situated in low income or disadvantaged communities. Some of you may have seen the news about the metal plating shop in Richmond. There's been a criminal prosecution going on there. Not that people have been injured, but the laws have been violated with the activities about how they were handling waste and how they were handling chemicals being too close to each other and things like that. So anyway, moving right along here. How many people here know about the Green Building Standards Code? Yeah. Well, you're ahead of the curve. I didn't even know about it until I read this. Anyway, California is the first statewide green building code, which is green materials to be used in building. It's a voluntary system at the present time, but this AB 341 is a process to transition out of the voluntary system into actually writing it into the California Code of Regulations, and then to actually be there for the next update of the California Building Standards Code. So if you have shares in a bamboo flooring company, you might want to be happy about it. Not that it will be the next Apple or anything, but maybe you'll be in good shape. So then we get down to SB 743. Now, how many people are familiar with the whole drama that went on through 2013 with reform of CEQA? Have you seen a lot of it? Did anybody hear about all the fun that everybody was having and everything? Sort of grimacing, Well, at the beginning of the year, Jerry Brown started out saying, we've got to do something about this for business. There's too much time that's wasted on appeals. Things get hung up. It just needs to be straightened up. It's sort of grown out of control. And it's not helping anybody. It is. So he wanted to do comprehensive CEQA reform. The chair of the Senate Environmental Quality Committee was a moderate Republican from Bakersfield, and he was championing this SB, or the law that was going to go through. But in January, Jerry Brown's talking about this. In February, Senator Rubio announces he's quitting the legislature and going to work for Chevron in legislative affairs. So the governor kept on going, trying to put together the stakeholder groups and everything to try to work out something, to get something going, along with Steinberg, who's the president pro tem in the Senate. And by the end of the year, what they did get was, one, a CEQA bill to exempt the 743, which exempts the King's Arena in Sacramento, Steinberg's from Sacramento, from the full CEQA process, but it is conditioned on a lot of green building stuff. This is a similar kind of exemption that they made for the new arena down in LA, and then also as explained in the paper, the Apple headquarters in Cupertino, that big donut thing that they're building over there, and I think the $1 billion McCoy solar project out in the desert in Riverside County. But anyway, that's what's happening with that. The problem was actually a judicial problem. The courts felt that the Constitution was being violated because of the decree by the legislature that something had to be done within a certain amount of time. An appeal could be made directly, instead of bypassing the trial court, directly to the Court of Appeals. And to overcome that, this SB 743 has a provision to require the Judicial Council by July 1st of this year to adopt a rule of court that sets a schedule for ruling on challenges to EIRs. And there's some other things in there, but you might keep that in mind. You need to look at that if you're getting involved in a CEQA litigation situation. And then there's another CEQA bill that, depending on probably which side of 50 you're on, maybe, huh? You're either for it or against it. It exempts from CEQA review. This is AB 417, bicycle-friendly actions by governments. Bicycle transportation plans, restriping, parking and storage for bicycles, timing of street signals and other signage. All that's going to be exempted from CEQA, and bring on the bikes, right? Actually, you know where the money to be made in that is? Probably the bike logs. Because Mayor Lee in San Francisco showed up at a meeting and riding a woman's bicycle because his last 5 bikes had been stolen. So somebody that has an effective bike lock is probably going to do much better, even than bicycles shops. Anyway, so now we can move on to some of the toxics. You know, it's like I used to say about asbestos. It's nothing to sneeze at. So now we have a new cleanup law, AB 440, which, by consensus of some attorneys that I know, they want to call it the Gatto Act, because it was someone in Gatto that sponsored it, put it through. There's been a change in the legislature recently, probably because of the criminal problems with some of the legislators, that they made a rule now that they cannot name any of the laws after any person. Probably a good idea, but anyway, this is going to possibly be called the Gatto Act to replace the Polanco Act. And we'll talk about that just in a minute. Then we're going to move on to talk a little bit about the regulatory agency developments. Let's see here. No, let's back up for a minute. This is just going to be a little discussion about what's happening with 440. As you know, we had quite a huge thing going on in this state with redevelopment agencies, brownfields. These are impacted properties. They would sequester the taxes from the area they were affecting. Areas were declared blighted. There's a big chunk of desert down in Southern California at California City that was declared blighted so that Toyota or somebody could put in a desert test track. So there was a lot of monkey business going on. But by and large, I mean, we all do like downtown Pleasant Hill, don't we? That's a very nice redevelopment project, at least in my opinion. So we ran into, there was money problems, there was some legislation, and there was some mistakes made by the redevelopment agency lobby group, and all of a sudden redevelopment agencies were gone in 2012. There was a big fuss, lots of people put out of work, and the money and the projects were then, everything was stopped, and what was left was delegated or shifted over to successor agencies. AB 440 attempts to fill this gap. It authorizes all local agencies, counties, cities, and, as my friend Joanne reminds me, housing authorities, to act basically as redevelopment agencies now. And so it has some additional powers and provisions the Polanco Act never had. Okay, number one, it applies throughout the entire jurisdiction of the particular agency. So, throughout, if Contra Costa County decides to use AB 440, there may be a redevelopment sort of type of project coming to your neighborhood. Or, you know, it'll happen, it can happen anywhere. You don't have to necessarily be within a redevelopment zone, which is where it was constrained before. This will be quite exciting for those counties that are like San Bernardino and Riverside. They're just ginormous. You know, they're as big as eastern states. But anyway, that's number one. Number two, local agencies are now authorized to investigate and clean up releases of hazardous substances. So they can do it on their own, and they can force you to do it. So this is a little bit different than the way the redevelopment agencies work. They had to condemn your property and then start that process by forcing you on threat of suing you for a cleanup. Another thing that will be quite interesting to see how this works out is that local agencies can require landowners to allow access. So if somebody shows up in your front yard, your client's front yard, and says, "Hey, come here with a drill rig to put down a monitoring well," you'd best move your roses or whatever, because the way the law is written, the local agency can require the landowner to allow access. The law also allows local agencies to require landowners to actually develop and turn over any environmental assessment information about their property. And you know, I don't know how much, well, I'm just going to assume that you see this all the time, because there's a lot of dancing around that goes on. Well, no, I really don't want to know about that. And oh, gee, maybe we shouldn't. You just keep that information yourself, or I did something, but I'm not going to really tell you about it. And we'll just pretend we didn't know, kind of thing that goes on in all these deals and transactions. This will have another element, another factor there. The further thing, though, is that March 13th, the Court of Appeals issued a decision in a case called Property Reserve Inc. versus Superior Court. And that was where the eminent domain law was being used for, I believe, for access without payment, if I got this right, to send in geological testing, drilling companies and whatnot to areas where the land and everything need to be evaluated for the Delta bypass tunnel project. And the people who were imposed upon by that found a lawyer and filed a lawsuit, and the Superior Court said, no, you can't do that. You've got to actually proceed in eminent domain, file an eminent domain proceeding in order to get that kind of access, because you are, with your geological studies and drilling holes and whatnot, you are actually taking some private property interest. So I would imagine there'll be a challenge to AB 440 in a given situation because of that. Local agencies also can cause a third party to do a cleanup and can hold on the property while it's being cleaned without becoming liable. The local agency is exempt from liability while it actually owns the property. And the definition of a blighted area, it's not the whole definition that you saw before. Now it's only enough that it's a brownfield, which is a much more liberal and general type of definition. So that restriction, or that constraint that used to exist, won't exist under this. And then there's another provision that has very strict time limits on preparing and reviewing investigation plans, cleanup plans, and public participation plans. So we'll see. There's a lot of need, a lot of desire for this sort of dual funding, private-public funding to get some of these bigger projects going. And particularly in the housing area. I mean, what, the average price of an apartment in San Francisco now is $2,000 a month? How exciting, huh? So, depressing in a way, too. I can be excited and depressed at the same time. I don't know, I guess that's California, huh? Anyway, that's what I have for statutes. Let's move on to regulatory agency developments. State Water Resources Control Board, also called the State Board. The big news there in this field, in real estate, is the underground fuel tanks, the reform of the underground fuel tank system, basically. A lot of tanks were being just started sitting there, lots of monitoring was going on, but nothing was getting done for years and years and years. I mean, there's sites that are 20 years that have just had monitoring. Well, when the UST Fund in 2009 looked in their account one day and they realized they couldn't write a check because they didn't have really any bookkeeping system that sort of tracked between what was being spent or going to be spent and what was actually coming in, a reform had to take place. And one of the reforms is this low-threat closure policy. And a low-threat closure policy will result in a no further action document. Okay? The trouble is, well, I'll give you a hypothetical situation. The trouble can be where, for instance, say you've got a site, it's got some dry cleaner schmutz on it, and it's got some gasoline schmutz on it, right? And so you're working along with your UST fund money. Consultant says, hey, you pay me when you get paid, I'll be glad to advance it. You kind of wonder if they're, got their thumb on the, like the butcher, the thumb on the weighing device or something. But that's not your problem. They just said they'll do what they'll do. Anyway, there's 1.5 million bucks. I mean, that can do a lot, particularly if you got a little mixed schmutz there. But if the state comes along and says, hey, this petroleum's cleaned up enough, you're a gas station. Once a gas station, always a gas station, right? Well, let's just leave it there. That's fine. Well, then you're kind of stuck because you still got the dry cleaner stuff. Or maybe you were thinking, this little gas station site really isn't making any money. I mean, the convenience store is where you make all the money anyway with a gas station. And, I need 1,000-gallon tanks in order to make it on gas. And this is such a small corner, like there's some over in Berkeley, Oakland, places like that, and around here. Actually, what I was thinking about was I was going to redevelop it into little units, maybe a little retail on the ground floor and a couple of floors of rental or something. But I'm not going to be able to do that now, am I? Because I won't be able to won't be able to get the money for the cleanup to drive the cleanup down to a residentially acceptable level. So maybe I'll put that open air parking underneath my building and let the wind blow through. You see that over at the East Bridge Shopping Center, by the way, if you want to look at the apartments around the edge of that, where it's interesting. They park the cars there and the wind blows through, and then the apartments are up above it. It does tend to help with the vapor intrusion issues. Anyway, that's a big deal, and there's lots and lots of sites that are being closed. There's a lot of complaints among the consulting industry, especially the small ones who work in this field about these things being done wrong. Where you get to, though, is a uniform. Now, I put in the paper here the eight elements that are supposed to be looked at to get a low threat closure. There's fudging that goes on with this by the agencies, and particularly if it's UST fund supported, they want to get the junk out of the system in their view, so that the money that they've got can be spent on the sites that are stuck. Because there are sites that you've got gasoline and stuff down in clay, and there's a drinking water well that's not too far away, and those sites get stuck. I mean, there's more work that has to be done. Maybe a huge excavation is the only way you're going to take care of it. Who knows? Anyway, put that in there. And then I also put in, for the benefit of everybody, the standard form letter, which is actually in the Health and Safety Code, which is your standard form no further action letter for a gasoline spill. That's called the uniform closure letter. Now, that's kind of the goal you're driving towards when you're trying to get a cleanup done. When you read it, of course, as lawyers, you'll see there's a lot of caveats in there. And you'll probably be taking it to the bank, and the bank will probably be happy with it because they've got a no further action letter. It fits their things, and they'll go ahead and make the loan. But no further action letters are no further action at this time. Is really what you ought to be thinking for the way contamination goes. Anyway, that's what's going on with that. Basically, regulatory reform effort there. There's some more work that's going on right now with whether the underground tank fund is going to be reauthorized 20 months from now. It expires on December 31st of 2015. And some of the consultants I've talked to have said they're going to have to stop work about January, this coming January, because of the lag time as far as getting paid. The paperwork goes in and it's reviewed, the money comes back out, because they want to make sure that the dollars that show up before December 31st are the dollars that actually go back into their project or their pocket or whatever that's actually paid. You don't want to be doing work sort of on the come. Well, I'll get paid when you get paid, and wind up, oh my goodness, the fund went away and the state has no money. You know, that's a sort of high and dry kind of problem. I think also I would recommend that if you're doing with all your real estate things, be very, very careful with your assignments from the original responsible party who has the right to get into the UST fund, and that assignment over to whoever it is that's buying the property, owns the property today. There have been serious problems for buyers. One I know in particular where the seller sold the gas station, and the way the contract was written is it was an as-is contract, and it was written in such a way that the seller would take care of any leaks before the sale, and the buyer would take care of any releases after the sale. But there was a little clause in there which said that that particular provision was subject to the as-is provision. So when the leak occurred or was found, and it did turn out to be from during the prior ownership because it had MTB in it. MTB hasn't been used for a number of years. The seller said, well, gee, you've got a problem here, don't you? You know, I don't think you paid me enough for this gas station, so how about some money? The buyer said, well, what do you mean? No. So they went to court, and the Superior Court found against the buyer, so the contract ruled, and the Court of Appeals affirmed it. And so their last chance was the regional board, and the regional board was understanding that yes, you know, let's name that prior owner, so the prior owner will transfer over these rights to this UST fund, because guess what? This is in a rural area, and the gasoline that's leaking out, it's kind of rocky, and it's kind of spread, and it's kind of gone down, and here it is in a drinking water well, not too far away. So they were concerned about it. Well, so then there was this fight in front of a regional board. And twice the regional board issued a proposed order where both of them would be named as responsible, which would have gotten that $1.5 million rolling in from the UST fund. And then a good lawyer went in and talked to the executive officer, and lo and behold, an order came out that said, oh, well, we're going to follow what the Superior Court, the Court of Appeals said, and gee, no, we don't think that first guy is liable because his contract took him off of liability. And the problem with that, of course, is that what's the government having to do with a contract between private people or saying that works in that way? Anyway, so be very careful with those as you're working with them. They're not as simple and straightforward as you might think. They can lead to problems, particularly with this uncertainty about the UST fund, what's going to happen with it, plus these sites are getting closed, people are not happy about that. Hey, it's a tough world out there, right? So, let's move on to something more fun like Prop 65. And you see Prop 65 a lot with consumer products, right? Labels and recalls and everything else, little shelf things over when you go to buy your fine china, they tell you that the leaded crystal's got lead in it. Don't put your acidic tomato juice in there and let it sit because you'll get a dose of lead. But Prop 65 also has to do with warning the public. Okay? Every restaurant has a Prop 65 sign someplace. A lot of times it's behind a potted plant of something, some sort, but it's there. The Prop 65 warnings are literally very, very diverse. So the governor's office, as I mentioned, was trying to get some legislation through. That didn't go through, but now they're going to do it through the regulatory system. So the agency that's responsible for this is called OEHA, the Office of Environmental Health and Hazard Assessment. Environmental Health Hazard Assessment, yes. And they're developing new regulations which will standardize warnings. The trick is going to be, though, well, the trick, that isn't a nice word, that's pejorative, right? The interesting aspect of this will be that this is the kind of warning that you see in a parking facility now, okay? You're being exposed to chemicals that the state knows will cause cancer and birth defects or other reproductive harm, okay? That's the warnings that are out there, and the plaintiff's attorneys are finding they cannot get past those to make the cash register ring, to get the penalties and get things changed. So in the regulatory system, and there was a hearing just, I think on the 12th of the month, where they actually continued it because there were so many people that showed up and had things to say about this stuff. This is the warning that's being proposed by OEHA for a parking garage. Breathing the air will expose you to multiple chemicals, and we'll name a couple of them, like gasoline vapors, carbon monoxide, and exhaust, that are known to the state of California to cause cancer, ... Do not stay in this area longer than necessary. And for more information, you go to this website. Again, remember, the internet's going to help us all out. That's why I say, the thing to do is get out of law and move into bike locks. You know, I mean, that's going to be the growth industry here. So this is going to create a lot of problems. It is already. I mean, it's hard for people to advance their thinking that something that they have accommodated and realized it's stinky and unpleasant, and you don't want to hang around in a garage too long, but to have a warning, particularly a warning, these are also specified as to how big the sign has to be and stuff, will cause some, is going to cause some concerns, and we could fight over it for a while.
So these have to be tailor-made for every business?
Well, actually, what they're starting off with 2 or 3 types of restaurants and parking garages and apartment houses. They're going to just address that. But if you're advising a business, okay, and there's any chance, like a dry cleaner, if there's any chance that there's going to be chemicals that are used in the dry cleaning process, that somebody's going to breathe them, or be exposed to them, then you need to have an indoor Prop 65 warning. Now, as far as your workers go, your workers are covered by your hazard risk system. They're through the industrial health and safety laws, and they're provided warning that way through safety data sheets and training and things like that. The third place, though, so you have consumers, you have workers. The third place is environmental exposures. Now, I know most people don't read newspapers anymore because they litter things up, but we love those little bags for our dogs, so we still take them. But every now and then you'll see an ad in the Contra Costa Times which said, we are the oil refineries, we've all gotten together and we put this Prop 65 ad in the paper to let you know that around our facilities there are Prop 65 chemicals. Okay? That's called an environmental exposure. So one of the big issues is whether or not the chemicals that are of concern actually go across the plant boundary and expose people in some fashion. Okay? So there's a lot of situations where it happens. In fact, years ago, Landals, Ripley & Diamond, a very well-known environmental law firm in San Francisco, they were in the Mills Tower building, the coffee building, and we got a call from the building owner at the firm I was at, and they said, somebody's complaining here because the buses are parking, sitting down there and letting their engines run, and the HVAC is pulling all that into the building. I said, well, you don't want to mess with those people because they're lawyers. So, Okay, so let's go to something even more fun. Toxic cleanups. Now, this is a picture of a bomb disposal. UXOs, if you're into the lingo of risk or of assessments, property assessments, and base conversions and everything. How many people here know what a UXO is? Unexploded ordnance. That's right. That's right. That does tend to get people's attention, when somebody says, well, we found UXO out there on that back part of that Air Force base that we're converting now. But I like this picture because it kind of brings home the the delicacy that one must have when dealing with toxic issues, and the carefulness that one must have. Now, that being said, that's kind of an attitude or an approach that's contrary to a lot of ambitious and proactive real estate development type people, right? And it was explained to me not too long ago when I got a situation like that where there was sort of a mismatch between my sort of feeling about this kind of stuff and the real estate folks, was that, oh, Jim, you shouldn't worry about it. They're so rich, they'll just buy their way out of anything. So I figured, oh, okay, good. Pay the bill. I'll give you the advice. Have fun. So anyway, this, though, is right on, I think, because you do have to be very careful, and you have to know what you're being told. You have to ask the consultants to explain it in maybe words of only 2 syllables. Not 1 syllable, but 2 syllables. And be very clear, because the way the rules work is that they're very precise, I think. Okay, let's move on to something that's also near and dear to our hearts, which is liability issues. Now, we're not going to get any ethics credit, so we're not going to talk about liability issues of lawyers. We'll talk about liability issues of our clients, okay? Anyway, this is the sort of the top of the mountaintop, the most extreme statement that we have in the law in California today. And it's been around since 1992. And you can see there that it's actually stronger than the responsible corporate officer language. And this has to do with underground tanks. This fellow Matthews had actually pled guilty or no contest to a criminal charge, paid a significant fine, cleaned everything up, and then he'd come in on a proceeding for expungement of the record, because that's what he wanted to do. And the Court of Appeals basically said no way, and they extended you have a significant share of corporate responsibility and power you're a person in control of or daily responsibility for, even if you're not you can be a CEO and have that, even at like Chevron or any large company. I don't mean to pick on Chevron. And a responsible share in the furtherance of the transaction which the statute allows. I think he'd gotten convicted because he was sending bad stuff off to the wrong place or something like that. Anyway, that's something that you need to keep in mind, and I would recommend that you share it with some of your clients at times when they're not listening the way they should to very valuable legal advice. Okay, so basic liability situation here. Let's see how we're doing on our time. Oh, we still have a few more minutes? Yeah, a couple more minutes. I know people got 9 o'clock, so they got to take care of. But the grandmother of all of this is Section 107 of the Federal Superfund law, which is called CERCLA. It's owner and operator liability. It's strict, joint, and several retroactive liability. This is what I mean when I say status-based liability. It's nothing you did. It's not who you are, the kind of person you are. It's just the fact that you exist. It's also based as a system of potentially responsible parties. You only get to challenge the enforcement that's being brought against you once the cleanup is actually done. Okay? You have trouble getting into court to say, well, wait a minute. You got the wrong guy here. That's called, with my friends in the DA's office, the Saudi defense. They hear it all the time. Saudi means some other dude did it. So, share that with you. And the petroleum exclusion in CERCLA was basically as I understand it, a trade-off between the petroleum industry and the chemical industry and the government when CERCLA was being considered. But petroleum products are not included in this scheme of owner and operator liability, strict joint and several retroactive liability, potentially responsible parties, and damages or recovery of cleanup costs. Petroleum exclusion is doesn't bar lawsuits under another statute, which I don't have up here, which is the Resource Conservation and Recovery Act. But that statute doesn't give you any money. It only gives you an injunction. You know, sort of like the Wizard of Oz said to the Scarecrow. You know, I can't give you any brains, but I can give you a diploma. So, you know, would you be happy if you only had an injunction and you didn't have damages? I don't know. I've got to figure that one out. Anyway, California Superfund is very similar. It doesn't have this liability provision, though, for citizen suits like CERCLA does. So it sort of stands in the background. It's the statute that authorizes a lot of what the Department of Toxic Substance Control does, and they are our sort of equivalent to US EPA. They're the uptight people with all the rules and regulations and everything else. As a result, a lot of people go on over to the regional water quality control boards, where they have more discretion. They probably, you know, take off at 4 o'clock in the afternoon. I don't know. That isn't true. But they administer all this under the California Port of Cologne Act. Well, the California Port of Cologne Act has got a little trick in it, is that it applies to anybody who, at its most extent, who threatens discharge into waters of the state. So if you own property and there's a possibility that the stuff will run off into waters of the state, you're in line. Ownership will do it. And if there's a historic problem, the first person they come after is the owner of the property. Okay? And keep in mind that liability is basically coextensive with the law of nuisance in California, which all of us who have ever read Prosser or heard Prosser talk, he basically said, what I got out of it was it's sort of like the Queen of Hearts, right? That's whatever we want to say it is. That's what nuisance is. So that's very broad liability. And when people who are trained in CERCLA and come from other states start talking about, oh, well, we're going to use a bona fide prospective purchaser and use our environmental assessment and we will be free of liability. We say, well, maybe if you're on the other side of Lake Tahoe or the other side of the Colorado River or across the border in Oregon, maybe you will be, but not here. Okay? So let's talk a few minutes about managing liabilities. The traditional concept with hazardous waste and hazardous and toxins and everything is, for heaven's sakes, don't lift up any rocks because you're not going to be happy with what you might find there. I have to say that if you really want to be able to sleep at night, you need to get ahead of the problem, ahead of the curve, ahead of the zombies chasing you, right? And you need to look before you own the property or before you go into operations on the property, okay? So that's why that little piece of clip art is there. And I, in fact, included in your paperwork here so you can actually put it on the wall or hand it to one of your clients or something. Okay, quickly, all appropriate inquiry was a system that came up through the federal Superfund, was developed by US EPA. It's basically that if you make all appropriate inquiry under the circumstances, you can receive a waiver or a pass or a defense against liability under Superfund. One caveat is that you've got to use due care after you find the bad stuff, and so you can't leave it out in the rain or whatever. But it still has provided a lot of help for brownfields. The parallel private system, which has now just recently become authorized by EPA as being as good as the federal rule, or interpreting the federal rule correctly, is the American Society for Testing of Materials, their due diligence standard, which is in a standard called E1527-13. It was revised in 2013. It's gotten a little bit broader than it used to be. So if you get a problem like this, give me a call because I'll be glad to chat with you a little bit about it. This explains where the all appropriate inquiry came from. The innocent landowner defense, that's the innocent land purchaser, the bona fide prospective purchaser, and the contiguous property owner. That's where those are supposed to help. But again, California, if you still got Port of Cologne out there, you still got liabilities. This is the back end. You've got to comply with all restrictions and controls, provide all the notices. And this goes into 1527.13. What are your real reasons? This is in the paperwork seller, you want to find a baseline as to what you're not going to be liable for in the future. And buyer, you get the relative liabilities. What are the real costs of the property, the effect of the contamination. So, now, this is an excerpt from the only case that we really have that's gone into all this stuff. Ashley, it was in the Carolinas, demolished the structures, but they failed to clean out and fill in all the sumps. So water came into the sumps. They didn't protect a debris pile from accumulating. And they let it sit there for a year of debris. They didn't maintain the rock and gravel cover on the site. And they had entered indemnification agreements with prior owners. So part of the BFPP defense is that you have no contractual affiliation except your buy-sell contract with people who are responsible. Okay, quick little test for you. This is about how fast you got to make your decisions too. You know, when they come in, they want to know, well, can I buy this now? Can I buy it? I got a deal. Property owner uncovers soil contaminated with lamp black. There's no immediate action required. It has benzopyrene, 10 parts per million. The volume of contaminated soil estimated exceeds 1 pound of this stuff. That's the reportable quantity. Okay, let's take a vote. Who says we got to report it? Who says we don't? First, let's say who says we don't have to report it. Okay, I'll give you an out. In law school, they teach you 3 things: yes, no, and it depends. So we'll let you use that. How many people want to say, well, it depends? Some will, huh? How many people say yes? Oh, look at this. Oh, well. You guys are too alert. Okay, this is the other one. Commercial parcel, truck wash, tanker trucks that haul pesticides and other chemicals. They dump contaminated wash water. After 10 years, the city revokes the land use permit. The property's abandoned. No cleanup activity. And guess what? You just inherited the property. What do? You disinherit yourself, right? You have to report it. Now, I've included in here, I believe I included the reference to the paperwork. Let's see. I think for the scenarios. Yeah, and then I gave you the statutory reference about who has to report what from the Health and Safety Code, the DTSC. And the key there is reportable quantity. You saw that estimation with that lamp black? You know, it's an acre. Maybe a very small percentage, but if it's an acre and you estimate it's a pound or more, that's a reportable quantity. So get the report going. So, are there any questions? I suppose I say just call me if you have any questions, because everybody's got to get back to work. So, any questions?
Thank you.
Just sort of blown you away, right? Sorry. Thank you.
Yeah, that's what you straight up. Yeah, I meant that. Did you do litigation and all?